Hello and welcome to another episode of Chai, Children of Adam and Eve on QF Radio 91.7 FM, a special dialogue program brought to you by Adil Khan of Doha International Center for Interfaith Dialogue, during the month of Ramadan, where we discuss research relevant to our lives today. We have with us Professor Sohaira Siddiqui. She teaches Islamic law and political thought at Georgetown University, Qatar. She is critical, to say the least, of our taken-for-granted contemporary understandings of the relationship between Islam, law and politics. Her scholarship is engaged with the contemporary world as much as it is immersed in the formative period of Islamic thought. We are grateful for her time today to speak to us about her research and her rather unique perspective on some of the hottest debates of our time. Welcome, Professor Sohaira.
Thank you, Adil, for having me.
What is Islamic law and what makes Islamic law Islamic?
So I think that's probably one of the most contested and questioned issues that is currently debated. So I would start by saying, in order to understand Islamic law, we'd have to divide it into four different areas, essentially. So the first is Sharia, which is what we normally hear to when questioned about Islamic law. And within the classical conception, Sharia refers to those certain legal rulings that jurists derived from the Quran or from the Hadith, which were the narrated sayings of the Prophet Muhammad, which could not be contested. So essentially, you could be 100% certain that this was God's law. So the Sharia, in that sense, is God's law. After that, all of Islamic law was essentially probabilistic. So you have the jurist's law, which was what the jurist created, answering questions that individuals had, or even reasoning potentially unclear verses of the Quran or unclear Hadith, which the Prophet said. And both the Sharia and the jurist law essentially functioned at the level of the individual and at the level of society. Now, if we talk about Islamic law in the modern period, we also have this natural link to politics. And within the classical period, there was also a similar link between the law and politics. And the two links were Qadi's law, which was understood as the law which judges would create. So any judge that was put into a court by a khalifa or elected or selected for a specific position, he would give a law in a specific case, and that would be considered the judge's law. If we think about it in modern day societies, that would essentially be the equivalent of juristic precedence, which is something very common within the British common law system. And the last type of law that we can think of when we talk about Islamic law is this idea of siyasa shar'iyya, which was essentially religiously motivated law created by the government. So they would use principles that the jurists would create, but they would create law for the benefit of the majority of individuals within society. So when we talk about Islamic law, we have to differentiate these different realms of Islamic law, which were essentially all present in the classical period and were either meant to address the individual, to address society, or to address this realm of the political.
Clarifying a bit this third notion of siyasa sharia, and a notion which you're probably quite famous for in your own research, the notion of maslaha. Could we understand this in our contemporary vocabulary as the common good?
We could potentially understand it definitely as the common good. Maslaha tends to be translated as public interest. The only caveat that I would add is that when we think of maslaha in the classical sense, maslaha, just because something was in the public interest, that didn't mean that it could go against the law or go against the Sharia or allow individuals to sin. So when we think of the common good in the modern day sense, it's this idea that the common good reigns above everything. But this idea of maslaha reigns, but it's still underneath God's law. And to the extent that you have something that could be in the public interest of individuals, but it violates God's law, then God's law will always trump it.
Could you give us an example of medieval or pre-modern practices of the state, where the caliph or khalifa comes in and does maslaha or a practice of public interest.
So a great example would be land tax or any type of tax. So if you look at the Quran doesn't have much to say about tax aside from, the zakat, which is the requirement of all Muslims to give. But when you had the expansion of the Islamic Empire, you had large swaths of land, you had farmers, you had all sorts of different individuals functioning in society that weren't necessarily there during the time of the Prophet. Now, to maintain an empire, just like to maintain societies today, you need to have some form of tax. And so a lot of the various taxes that were created, whether it be land tax, whether it be tax on crops, whether it be tax on sheep or camels, a lot of these were created based on maslaha.
Why is that different from the creation of ijtihad or reinterpretation of the essentials of law by the qadis? Is it just because the administration or the caliph is doing this legal, if you will allow the word, innovation?
Well, so I think the key distinction to draw between the qadi and the khalifa is a matter of jurisdiction. So if we think about it in terms of the common law system that we have today, if a judge gives a specific ruling, that ruling is binding on the individual that the ruling is given for, but it's not binding on all individuals. And so similarly, if the qadi in his position as a judge gave a ruling, that ruling is binding for that specific individual only. It can be used later as precedent, similarly as it's used in the common law system, but the idea is that it's only applied to individuals and individual cases. Contrary to that is this idea of maslaha, in which the khalifa decides what is in the general interest of people. Once he decides what's in the general interest of people, the jurisdiction then becomes all people as opposed to the individual. So that's one of the distinctions between what the qadi says in his courtroom and what the khalifa says in his position as the khalifa.
This has already gone quite a distant into an understanding of the relationship between the political and the law in Islamic legal thinking. Would you clarify further the relationship that we need to understand as contemporaries, the relationship between the law, between the political in Islamic law?
So if we go back to the original distinction of Islamic law as being these four different things, you had the Sharia, you had jurist's law, you had the qadi's law, the judge's law, and then you had the realm of siyasa shari'iyya. The realm of the political comes into siyasa shari'iyya predominantly because that is where the khalifa is deciding what is in the best interest of the Muslim population or the population he's ruling over. Now, the jurist preferred to kind of keep a degree of separation from the khalifa. They understood that what they were trying to do was they were trying to reason out what God's law actually is. And to that extent, because they had a variety of texts in front of them, and because there were so many jurists, they had to accept probability in their ideas. And so the realm of the jurist was always going to be the realm of the probable, something that they would create for individuals and for society. On the other hand, the realm of the political became siyasa shar'iyya, and it became the realm of the entire community. And what the Khalifa was trying to do was trying to rule based on the public interest of individuals. He wasn't necessarily concerned with what God's law was. And anything that he was creating was not God's law in any sense. It wasn't even an estimation of God's law. It was merely what was in the public interest of individuals. So the difference becomes is when you are ruling for the public interest of individuals and applying it to all individuals, you can do it uniformly, similarly to how it's done in modern states today. And to that extent, it is the realm of the political. But if you are trying to reason what God's law is, then that's always going to be the realm of the probable, and therefore there will always be a plurality of opinions, which is what characterized Islamic law for the majority of its history.
So understanding this distinction between the probable and what is applicable to the whole community is very helpful for our contemporary ears. But how would you help us understand further the notion of Sharia itself? Because it has, as we well know, in the contemporary period, been mobilized as a term for political revolutions and political activism. Is it not that Sharia was the maruf, or the commonly held understanding of what is known about God's law?
So the Sharia is that very narrow realm of that which is 100% certain within Islamic law. So if we think about basic prohibitions such as not being able to drink, not being able to eat carrion, not being able to have pork, these are very basic prohibitions that are 100% certain when it comes to the text, and therefore can be the realm of Sharia. Now, when classically understanding the Sharia, it was always this very narrow realm. What's happened in the modern day period is that we've become very loose with our terminology. So when you're talking about this idea of mobilizing the Sharia, individuals are trying to mobilize is not this very narrow body of laws which everybody agrees upon, but what individuals are trying to do is they're trying to take all of those laws which the jurists understood as probable and somehow make them certain, and then take those laws and then have them implemented within a society or within a culture, within a space, within a political realm. So they're stepping away from this classical understanding of the Sharia being very narrow, a very narrow set of laws, to this larger understanding of the Sharia as being all law.
So then, would you say that the realm of Sharia in the past was the realm of the non-political in Islamic law, because it was beyond the politic, anapolitical, as it were?
Exactly. And even if you take from the name Sharia, in Arabic it means the path to a watering hole. The understanding being that it was the path to God. It was not the path to politics. It was not the path to create a political community. It was the path to God himself. And that's why when the jurists tried to create law, they weren't creating law for the realm of the political. They were always trying to get to an estimation of what God's law was, understanding that law itself was a path to God.
You are listening to Chai, Children of Adam and Eve, on QF Radio 91.7 FM, a special dialogue program brought to you by Adil Khan, where we are discussing today Islamic law with Professor Sohaira. Professor, are the boundaries between the political and non-political so porous that now in our contemporary times the difference between Sharia, Siyasa Sharia and fiqh seems to be almost at times synonymous and at times confounded to a level that are very difficult to understand for observers?
I think that's a great question. I don't think they were always so porous as they are now. And I think it really depends on how much the individual has with regards to Islamic knowledge. So if you poll a lay individual on the streets of England and you ask them what the difference is between precedents or codified law or between civil law and all of these different things, the chances are is the individual won't know these distinctions. And similarly within Islamic law, if you ask them the difference between the Sharia versus fiqh versus Qadi's law versus Siyasa Sharia, the individual is not going to know the distinction. So they're porous to the extent that the individual might not have knowledge of it, but if you have an individual that knows the legal tradition well, then that individual will be able to demarcate where the Sharia stops and where the fiqh begins and where the fiqh stops and something else begins.
In a sense, we have already mentioned the British legal system and suggested that ordinary British folk might not know the legal nuances of the differentiation between their law and the rest of European law. Would you say that at times of crisis, there has not been a precedent in European history where lawyers and judges have taken to the streets for preserving their institutions? But is that what has also happened, that legal specialists in the Muslim world, having been oppressed and having not had the chance to express their legal knowledge, have taken the direct channel of revolution and revolt?
Well, I think the topic of revolution and rebellion and revolt is something that is a highly contested one. So if we're speaking about the current revolutions and the current revolts, then there were definitely some jurists that went and exercised their freedom to rebel, and there were others that said no, rebellion is not permitted. There's a very rich juristic discourse on when and why rebellion is permitted and when it's not permitted. One thing that I can say is that based on Islamic history, this is one of the reasons that the jurists liked to keep a healthy distance from being involved too deeply with politics. It was understood that the Khalifa should take advice from the jurists, and the Khalifa should consult with them. But for the most part, the jurists had their own separate realm in which they functioned. And the institutions of the jurists and the practice of the jurists was very important. Now, in the modern day period, many individuals have criticized that juristic discourse is not as rich as it once was. One of the issues definitely could be that they don't have the space politically, but also the institutions the jurists need have not necessarily been the recipients of funding, and there's all sorts of different factors that have led to the weakening of juristic discourse in the modern period.
Another reason which comes to mind perhaps might be to do with the funding of juristic institutions of knowledge transmission. For example, the traditional view perhaps has been that endowments or okaf were not the only source of support for jurists and their educational system, but that ordinary people were also involved heavily in the funding of their local teaching institutions of law. Would you agree that that has significantly changed in the modern period?
I would definitely agree. I think if you look at 11th century Baghdad or 11th century Nishapur, what you would see is that a lot of the kind of the intellectual strength of the jurists was actually attached to the strength of specific families that were their patrons. And I think both the system of patronage and the idea of endowments, or even the mere presence of endowments, has definitely decreased in the modern period, to the extent that the jurists don't necessarily have financial independence. They're not going to have intellectual freedom in some sense. And to the extent that jurists have to be employed by the government and there are few institutions, they're always going to be limited in terms of how much advancement we're actually going to see intellectually.
And one last quick question, Sohaira, before we have to leave, which is, what is the theology of the political in Islam? Does God really intervene into the political?
Islam, I think it's a fascinating question. I think if we think about it just in terms of if there's a bad ruler, will God somehow create some catastrophe to take away that ruler? No. God doesn't necessarily interfere in the kind of the day-to-day political affairs that are taking place in any country. But at the same time, Islam is teleological in the sense that history is moving towards a specific direction. There's a specific end to history which is there within the Quranic text, which is there within the Hadith. To that extent, God is continuously facilitating the movement of society towards that specific end. Now, if that specific end requires certain political changes and certain types of changes within society, which it does, then those changes will naturally come about. But in the kind of mundane day-to-day, there is no understanding that God is interfering with the political.
And with that, our time comes to an end. Thank you for listening to us. Thank you, Professor Sohaira, and Ramadan Kareem to all of our listeners. Would you like to say something to our listeners, Professor Sohaira, before we leave?
Thank you so much for listening, and I hope this conversation continues both on the radio and off.
A special thanks to Ehab Al-Sheikh for bringing this program to you.